Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party of Los Angeles County versus Bowen, 709 F3D 867, Court of Appeals, 9th Circuit, 2013. Friends, the Libertarian Party is advancing the cause of ballot access once again. So let's appreciate them today. This case takes place in California. Anybody out there from California? Let's find out what happened in this case. I'll read from the record. It says, quote, to qualify for the ballot in California, political candidates must file a nomination paper that includes a certain number of signatures from registered voters. Cal Elect Code Statute 8062-8409. Commonly, candidates appoint persons known in California as circulators to circulate the nomination paper for the purpose of gathering signatures. At issue here are the California Elections Code sections 8066 and 8451, which mandate that circulators shall be voters in the district or subdivision in which the candidate is to be voted on and shall serve only in that district or political subdivision. Plaintiffs, Libertarian Party of Los Angeles County, Theodore Brown, and Christopher Agrella brought this pre-enforcement action under 42 U.S.C. Statute 1983 against defendant Deborah Bowen, California Secretary of State. Plaintiffs allege that the residency requirement violates the First and 14th Amendments and accordingly seek to enjoin its enforcement. End quote. We've come across similar laws in other cases in other states. Some of these cases involve laws that state strict requirements for people who can sign the signature, such as having to reside in the state or in the district. Here, this is not just the state, it's the district. It has to be the exact district. So if you live right on the edge of one district and you want to go a few blocks over, it doesn't sound like you can do that here. Our friends here also invoke the First and 14th Amendments. We've been seeing that again and again in these ballot access trials, so we applaud that. Way to go, Libertarian Party. Way to go. Much of this case does not center on the issue itself, the issue of whether they should be allowed to do that, but whether they should hear it in the first place. The case talks about the issue of standing and the issue of injury. They say you have to prove an injury to sue. That would seem to be basic civil procedure. Now, of course, the notion of having an injury to sue is one thing, but as this case discusses, and other cases are discussed, injury can be hard to determine, especially in something like this, where property isn't damaged, it's not a matter of theft, so it's harder sometimes to determine the nature of the injury. But the court says because the issue involves First Amendment, that makes it a lot easier to determine the nature of a potential injury. So in this case, they talk about how the Secretary of State does threaten them if they don't comply with this. So it talks about how they get scared to not fall in line with these orders. So it's not whether they violate or not, it's the potential of possibly violating it. So it's good, as this case discusses, the Libertarian Party is being proactive. They don't want to get in trouble, so they want to take care of this ahead of time. We like to see that. So ultimately they decided as follows. It says, quote, in sum, defendant had promulgated instructions for candidates to describe the mandatory qualifications of circulators, and she has advised them that any person filing a false affidavit should be reported to authorities for criminal investigation. In these circumstances, we hold that the defendant had communicated a specific warning or threat of enforcement. End quote. And then the ultimate verdict is this, quote, reversed and remanded, end quote. So our friends of the Libertarian Party won round one. Now they got to go back to the trial court and argue the case. But they did get a first step. So let's hope they prevailed. Friends, let's keep going. Long live the First Amendment. And also something else. Because the First Amendment pertains to this. So I say to you, what else are we going to say? Long live third parties. Goodbye.